Everybody, it's just gone 10 o'clock. So we are on day number 3 and we'll reconvene the inquiry. Are there any issues, the council, are there any issues with the IT that I need to be aware of? Okay, have we heard from Mr. Ogborn or Dr. Keith? Okay, no, that's fine. The site visit in particular, Mr. Ogborn did suggest he may wish to visit on this, attend the site visit. But no, he's not communicated with us on that. So on that basis, we'll probably proceed on the basis that it's going to be an unaccompanied site visit unless Mr. Ogborn makes representations in the meantime. Sorry, just moving the microphone there. Is there anything I need to be aware of overnight? Any further documents or evidence?
Just to update you ahead of the conditions session, there's been some discussions between the parties in relation to the wording of the conditions, picking up the point about the additional access points. So we can update you on that when we get there, and we've got some suggested draft wording which we can talk about. And so just to confirm, thank you very much. We have had by Rebecca Luxton your comments on the conditions, and obviously both parties will pick those up in the session. Yes,
they're just a kind of a guide in a guidance really, yeah, to kind of structure the session. And yeah, I think they've only just been sent through. I did send them through yesterday evening, but I think they've only just been sent this morning. So yeah, okay, that's fine. I didn't make any comments on the Section 106 agreement, but we will cover that during the session. The only other email I did send was just updating the inquiry documents list. Yes, and the accompanying request was, can you make sure that if I haven't got electronic copies of everything, that they are sent? So don't send them in again, but if something hasn't been sent already electronically, then please do send that across. Apart from the site visit itinerary, which I don't need electronically. Okay, so Mr. Brown, you're due to give evidence today. Where are you sitting? I know we did use, that's fine. If you're comfortable sitting there, that's fine. Okay, so in your own time, if you'd just like to take a seat at the witness table. And as I said to Mr. Phillips, do make sure there's a glass of water. I know there is a jug, but okay, that's fine. And I will now hand over to Mr. Walton to introduce your witness.
Thank you, sir. This is Colin Brown. Mr. Brown, you tell us in your proof you've got a first-class Bachelor of Arts degree in Town and Country Planning from Newcastle. You're a chartered town planner, and you obtained full chartered membership of the RTPI, the Royal Town Planning Institute, in 1992. You've got over 30 years experience as a practicing town planner, and you're currently a partner and head of planning and development in the planning and development team at the Cambridge office of Carter Jonas. All correct. So with your steer from earlier, we'll take all the evidence obviously as read. And just a very few points to pick up on, please, by way of evidence in chief. Will be a few moments, nothing more. The first point, Mr. Brown, please. Affordable housing. You heard yesterday from the council in terms of the where they said they've got to an affordable housing delivery and the weighting that they would give to this scheme, the benefits this scheme would deliver in terms of affordable housing. Where are you on that, please?
Thank you. Yes, so the weighting that I would give to that remains that it should be given substantial weighting. We heard obviously from Mr. Phillips yesterday afternoon about affordable housing completion levels in the recent period, and his assertion was very much that the delivery of affordable housing is improving and that the shortfall is effectively reducing. That's not the position that I take on this. Whilst it is correct that the stated number of affordable housing units by way of shortfall has diminished because of the most recent schma, that arises principally because the method of calculating affordability in that latest schma has changed. But the actual level of completions has been still very, very low, I would say. And if I can just refer, please, to CD 4.34, which is the, I think it's the October 2023 AMR interim report. And if so you turn to the very, very last page of that document, table 3, we will see the affordable housing completions since 2011, 2012. And if you take the 10-year period from 2011 through to the end of 2021, the total number of completions was 479. That is an average of just under 48 completions per annum. Since then, I would accept that the level of completions has increased, 154 in 21-22 and 181 in 22-23. But what that is simply doing is it's meaning that over the 12-year period, so if you take each of those years in aggregate of 814, over that 12-year period, the average is only 68 dwellings per annum. And Mr. Phillips did acknowledge yesterday that the assessment is that going forward, the requirement from 2020 through to 2040, so beyond the current plan period, is going to be 215 dwellings per annum. So over the last 12 years, the average delivery has been 68. The requirement is actually going forward 215. So even if you take the last 2 years where completions have increased, so to 154 and 181 respectively, those are still falling short of the council's target. So in fact, over the last 2 years, the shortfall has grown, not actually reduced. So I think when you look at that in the round, you know, the affordable housing need in this district remains critical. It remains acute. These are homes for the most vulnerable members of society, and that's why I place substantial weight on the delivery of additional affordable housing arising from this scheme.
Thank you very, very much indeed. Heritage, please, is the next point, and just unpacking that, the point that the inspector made yesterday, unpacking the difference between the accepted and agreed impact being less than substantial harm, and the weight that then gets attributed to that impact applying policy. Just to set out your position on that, please.
Yes, in relation to that, I do accept that the table in the statement of common ground, which we obviously looked at on a few occasions yesterday on harms and the weighting and the benefits of the weighting of those is not expressed quite in the way it should have been. And, you know, I do accept that in terms of national advice, you know, great weight should be applied to heritage considerations in the decision-making process. What really this table has captured, only in part, is the actual level of harm, which obviously we have said is low to moderate. And I think that was an agreed position at the last inquiry as well. So whilst it is correct to say that great weight should be given to that, the level of harm is low, it's less than substantial, low to moderate, and therefore if the benefits of the scheme, the public benefits of the scheme are seen as being substantial or significant, which we say they are, then that harm can be overcome.
Thanks. And obviously it's common ground that applying that sort of gateway heritage test, do the public benefits outweigh the heritage harm? They do, taking us through to the wider analysis as to whether there are very special circumstances, taking all benefits and all harms properly weighted into account. Okay, that's enough on heritage. Next point, please. Growth 2 and housing 6, the tie-in between those two and how you've gone about dealing with those.
I'm just going to find the policies. So I've got them absolutely to hand.
CD 3.1.
Yep, got that. Thank you. So, I mean, my position on these is as follows. So, if I'll start with growth 2, and growth 2, which we've heard obviously quite a bit about, is the locational strategy policy. It says very clearly towards the end of that policy that certain types of development may come forward outside defined development envelopes. And there is a list of potential uses that may come forward in that regard. And one of those is described, and I think Mr. Phillips agreed in shorthand form yesterday, as residential care homes, and then you're directed to policy HOU 6. I think importantly, in the paragraph that precedes the bulleted uses, specifically says that development will be limited or restricted to the main categories listed and may be permitted as an exception. And then the key words here are providing there is no significant adverse impact on the character of the countryside and the other local plan policies are satisfied. So that's what growth 2 tells us. We then need to look, obviously, as directed to HOU 6, and this is obviously described under the umbrella term residential care accommodation. If one looks at paragraph 4.7.3, which is one of the explanatory paragraphs, this is on page 50 of the local plan, CD 3.1, then it makes it very clear there that there are various different types. There are several options for residential care accommodation, and it breaks that down into retirement homes and villages, extra care housing, and then it goes on to say other forms of accommodation include care or nursing homes, which comprise single rooms within a residential setting where residents receive varying levels of care, and it goes on to describe what that care might involve. If you then look at the policy itself, there was a discussion yesterday about the second part to that policy, which is the part that allows proposals exceptionally outside development envelopes. And Mr. Phillips was taken to those and gave his view on each of those bulleted points. My position, I think, differs from Mr. Phillips here because I don't consider that those bullet points are actually applicable in this case. And the reason for that is that the policy states clearly that this is for proposals for care or nursing homes. This is not a care or nursing home. And I think that's commonly agreed by all parties, and it was discussed again yesterday. So to that end, I don't really think that HOU 6 takes us sort of very much further. Growth 2, as I said earlier on, already acknowledges that these proposals may be acceptable outside development boundaries, and that's the wide range of C2 uses, as Mr. Phillips conceded yesterday. They may be permitted in those locations subject to there being no significant adverse effect on the landscape. And I think, again, it is common ground in this inquiry that there is not a significant adverse impact in that regard. So my view is that the proposal is compliant with growth 2 in that context.
Thank you. Very sorry. So with all that in play and that step change, frankly, in the LPA's position too, where are you in terms of how the balance should be struck?
I think, very plainly put, I think that the case for granting planning permission is extremely strong. The council has not been able to evidence anything that could come forward in any meaningful timescale in order to meet the critical need which government advice tells us there is for older people's housing. And obviously, as we've just touched on, an added benefit of this scheme is also the affordable housing aspects, although obviously they're to one side slightly on this issue. We did what we consider to be a robust alternative sites assessment. The council quite properly had that independently reviewed by Gerald Eve. Gerald Eve identified certain sites which they felt we had not addressed at all, and I think it was in Mr. Smythe's opening that we hadn't even referenced those sites. Well, I think we've subsequently established that was not correct. I think there were only 5 sites that hadn't been considered in our alternative sites assessment, and the evidence we've heard through this inquiry has taken us absolutely no further forward on any of those sites. Frankly, none of those will be achievable within a time frame, or they're not available, or they're not suitable. So from that perspective, this is the only show in town. This site is the only site that can deliver for this critical need. And I think, therefore, the position that I felt was already a very strong position prior to the inquiry has strengthened further during the inquiry, and certainly following Mr. Phillips' cross-examination yesterday. And therefore, my assertion is that the benefits of the scheme do significantly outweigh the harms, and therefore I think there's a very clear path to a grant of planning permission.
Thank you, sir. That is evidence in chief.
Okay, thank you. If I do have questions, they may be addressed in cross-examination, so I will leave any questions until after Mr. Smythe. Are you ready to go? Okay, over to you, Mr. Smythe.
Yeah, morning, Mr. Brown. We can agree that the council has a 5-year supply.
We can.
And it's not precarious. Some councils have got a supply of, say, 5.1, 5.2 years, where it may dip in the near future, but it's a strong 5-year supply, isn't it?
It is not precarious.
The inspector should give full, subject to adoption tonight, the inspector should give full weight to growth 1 and 2.
Yes.
About 3% of the district is covered by Greenbelt.
Yes.
It forms no part of your case that the Greenbelt designation in this district is stale or no longer serves a useful purpose.
That is not our case.
And it's no part of your case that the area of land around Bottisham is not aptly included within the Greenbelt or is a ripe candidate for removal or release from the Greenbelt.
That is also not our case.
Can we take up the framework? And it's paragraph 47. I don't think it's a core document, but
if you just bear with
course,
me,
yeah.
I will need to call that up. Precise moment where I have no internet. I don't know what's happened there. It's dropped out. You just have to give me 2 seconds.
Do we have a paper copy anywhere of the framework?
It's not a core document. I can probably get back online in literally a second if you just give me a moment. It's just a bit, I think it's because I shut the lid and opened it again. No, it's come. It's open now.
Yeah.
So I'd say sorry. I'm now online. So
yeah,
my attempt now to access the MPPF should succeed. Sorry, I should have had a copy to hand.
No,
My
not at all.
apologies.
No. And as Mr. Watson said, I don't think it will be a reference, which will probably. But
I have it.
yeah. So that encompasses a statutory duty, doesn't it?
Sorry, what was the question?
So paragraph 47
Para 47.
The first sentence summarises what the statutory duty says.
Yes, it does.
So the inspector has a twofold task. First stage is the inspector needs to reach a judgment as to whether the appeal complies or is inconsistent with the development plan as a whole. Do you agree?
I do.
And then once he's reached that judgment, to decide whether there are material considerations which point the other direction, which means that a different decision should be made.
I agree, and that would be the very special circumstances test.
Understood. Where in your proof do you tell the inspector whether you think the appeal complies with or is inconsistent with the development plan as a whole?
I mean, the approach I have taken in the proof is to run through all of the policies that are relevant to the consideration of this matter and to assess the degree to which or otherwise the scheme complies with those policies. And there is an acknowledgement that in some regards they do not. But what I would say in relation to this point is that ultimately, with the substantial weight being given to the benefits and also substantial weight being given to the harms, the key issue then is whether or not the very special circumstances have been demonstrated. And if those very special circumstances have been demonstrated, then going back to paragraph 47, the inspector would have exercised his duties properly by effectively allowing the scheme in that context, because the very special circumstances constitute material considerations.
I understand you need to look at each policy individually, but the statutory duty requires the decision maker to then reach an overall judgment as to whether there's compliance with the development plan as a whole. So if I could repeat the question, where in your proof do you give that overall judgment to discharge the statutory duty?
Well, as I've sought to say, that is in the overarching conclusions about the very special circumstances being in existence. I don't believe there is necessarily a single paragraph in there that says in the round, the position in, the compliance of the development plan is satisfied in that context. But as I say, the very special circumstances is the primary issue here. And if those exist, if those are in play, even if there are individual conflicts with particular policies, effectively permission should still be granted.
But why be so coy, Mr. Brown, if it's the appellant's case that the appeal complies with the development plan as a whole? Why wouldn't you say that clearly and expressly in your proof of evidence?
Well, I think in my answer to you now, I'm saying that with very special circumstances demonstrated, in my view, I'm happy to say that the development plan is complied with. Policy ENV10 is the policy that addresses Greenbelt in an East Cambridgeshire context and in the context of the NPPF. And therefore, whether it's written in precisely the words you've suggested in my proof, I'm happy to confirm here that in the round, that would be my position.
But aren't you mixing up the two stages? Because the inspector needs to decide whether there's compliance with the development plan as a whole. He then needs to look at material considerations. And that the very special circumstances come in at that stage, don't they?
Well, yes, that's correct. I accept that. I think the point is, and I think Mr. Phillips conceded this point in cross-examination also yesterday, that when one actually looks at policies, there are some that will pull you in one direction, there are some that will pull you in a slightly different direction. My view is that in terms of those policies that we don't comply with, I don't think that those are of such significance that one would conclude that we don't comply with the development plan as a whole. When you then add the material consideration of the very special circumstances on top of that, I think it's, the position is pretty clear.
We can agree that the appeal offends ENV1.
Rather than just
yeah.
sorry, look at each of those policies in turn, if I may. Yes, we can. Yes.
We can agree that the appeal offends ENV2.
Yes, that has been set out in my proof.
We can agree that the in respect of growth 2, compliance with growth 2 is contingent on compliance with HOU 6.
Well, I think you need to read those two policies together. You know, what one does reference the other, or growth 2 references HOU 6. And as I said in my answer in evidence in chief, I think that growth 2 gives us the necessary direction on the acceptability of this proposal outside a development envelope.
Has your view changed about whether there's compliance with growth 2?
I don't believe it has, but I'm just going to. No, I don't think it has.
Did you write the planning statement?
No, I was not. I did not write the planning statement.
Can we take up the planning statement? It's called document 1.2.
Yep. Yeah, I have it.
So we can see that it was drafted by Carter Jonas, but it wasn't. Sorry, go on. Yeah.
No, that's correct. It was.
Yeah, and this was the purpose of the planning statement is to provide the justification and planning case in favour of the appeal.
Yes.
And if we turn to page 26, the conclusion. Towards the bottom, paragraph 4.104, the recognition that it's inappropriate development. And then at paragraph 105, there is conflict with policy growth 2 of the development plan identified. However, the weighting to be given to this policy is tempered by the fact that it's out of date.
That is what the planning statement does say.
Do you agree or disagree with the planning statement?
I did not write the planning statement, as I said. My evidence to the inquiry, having come to this afresh as not the person who dealt with the planning application, is that I don't think there is a conflict with growth 2.
Did you see a draft of the planning statement before it was included in the planning application?
I did not.
Does it come as a surprise to you?
It's not a position that I adopt myself. So, yes, I suppose it does.
Because the author of the planning statement finds himself in good company, because the author of the planning statement's agreement that it conflicts with growth 2 is the council's position, and it was also the position of the inspector last time round, wasn't it?
I believe that's the case, yes.
Let's look at what the inspector said. I've got it at appendix 2 of Mr. Phillips's evidence, and it's paragraph 55.
Sorry, just give me two moments
to
call that up, if I may. Sorry, just bear with me. There are, as you know, a myriad of documents here. sorry, appendix number
I've got it. I think it's in a number of
2,
places. Yes,
appendix 2. Yeah, I've got it. Yeah, okay.
And it's internal page 10,
Yeah.
paragraph 55. So the inspector,
I'm there.
yeah, so the inspector finds low to moderate harm to the character and appearance of the appeal sites. That's the same, that's carried forward to this appeal. That's common ground. The proposal conflicts with ENV 1 and ENV 2. Again, that's carried forward and is common ground at this appeal. And the inspector said the retirement care village element proposal also conflicts with policies HOU 6 and growth 2 of the local plan. However, it's almost impossible to imagine a scheme of reasonable scale proposed on a greenfield site which would not cause some harm to the character of the locality. This is recognised by the framework. And so then he goes on to say at the very end, I therefore place limited weight on the conflict. You see that?
With ENV 1, ENV 2 and HOU 6.
Yes.
Yep, I see that.
And then we then get his conclusion about the weight to be given to the conflict with growth 2 at paragraph 56.
Yes.
And he records that it's common ground that growth 1 of the local plan is out of date because the housing requirement figures are more than 5 years old.
Yep.
Growth 2 is the key policy for directing the location development in the district. It focuses the majority of development in Ely, Littleport and Soham, and within defined settlement boundaries. The policy strictly controls outside these boundaries. This locational strategy for development is based upon out-of-date figures from growth 1. A single issue review of the local plan is underway, but it's at a relatively early stage. It's common ground, and I agree that until this review is further progressed, it can carry limited weight. We are therefore in a position where we cannot know with any certainty what the future locational strategy for development will be, and specifically whether or not its strict controls over development outside the settlement boundaries will persist. Therefore, I place limited weight on the conflict with growth 2 identified above. Do you see that?
I do.
So the reason why the inspector gave so little weight to the conflict with growth 2 is because there was a question mark hanging over the future locational strategy and the extent to which the local plan strictly controls development outside settlement boundaries. Do you agree?
Yes, that's what the inspector concluded.
If the single issue review is adopted by the council tonight, that uncertainty is eliminated, isn't it?
If it is adopted tonight, as I've already conceded, growth 2 can be given full weight as a companion policy to growth 1, but that doesn't change my conclusion overall about whether or not there is compliance with growth 2.
If this inspector reaches the same view as your colleague who wrote the planning statement, the council and the previous inspector, that the appeal is contrary to growth 2, we can agree that significant weight ought to be given to that conflict, given that full weight needs to be given to growth 2.
Yes, that would be the correct position to adopt. My caveat would obviously be, having regard to the paragraph we referred to earlier in the MPPF, you then need to look obviously at other material considerations. But yes, as a matter of principle, I agree with that.
Understood. So now let's have a look as to whether growth 2 is in fact offended. Can we take up growth 2 in the local plan, which I think is called document 3.1? Yeah.
Yeah, I'm there.
Yeah, so it's internal page 25. I'm going to take it the inspector's read the policies. I don't want to, and it's been summarised when I read out the previous paragraph of the inspector's decision. But we've got a pyramid, haven't we? We've got majority development focused in the 3 towns. And then next layer down, if you like, next layer up, more limited development within settlement boundaries. And then at the top of the pyramid, I'm mixing my metaphors, we've got outside defined settlement envelopes, development will be strictly controlled. You see that? And we then have the exceptions with the bullet points given beneath that.
Yes, I see that.
And the expression development will be strictly controlled is a clear steer from the local plan that one ought not to lightly have development in the countryside, and it should only be allowed if it meets one of those bullet points listed below.
I would say that is a correct interpretation. What I would go on to say, though, is that if the uses that are then described below, including residential care homes, are not meeting a demonstrated need within development envelopes, then I think that would justify the exception being taken into account in growth 2.
And it's your case that there is compliance with growth 2 because the HOU 6, which is the bullet point, the 4th bullet point down, residential care homes, see policy HU 6. So it's your case because the appeal complies with HU 6, it therefore gets in the exception, which means there's not conflict with growth 2. Do I understand that?
No, I don't think that's quite right. What I'm saying is that growth 2, I think, is the primary locational policy. It is the locational policy of the local plan. And it's under growth 2 that we can, I think, justify a proposal outside a development envelope in the circumstances described as part of this appeal, the needs, etc., which I won't sort of go into again, provided there is no significant adverse impact on the character of the countryside. So I think growth 2 in and of itself gets you to that place. HOU 6 then provides more detail on that precise land use, but I think it's that way around rather than the way around you just described it.
If we look at that paragraph, what I've called the top of the pyramid, outside defined settlement boundaries, development will be restricted to the main categories listed below and may be permitted as an exception, provided there's no significant adverse impact on the character of the countryside. Pause there, it's common ground, it's low to moderate, so that's not offended. And it says, and that other local plan policies are satisfied. Do you see that?
I do see that.
Well, you must offend growth 2 because it's common ground that the appeal breaches ENV1 and ENV2.
Sorry, I'm just turning back to the policy again. I mean, my position on this is that this is where you need to carry out the balancing exercise, and I can't think of many developments where there have not been certain policies that, you know, would direct you one way and other policies would direct you in a different way. As a decision maker, you need to make a planning judgment and you need to arrive at an appropriate position on that. I don't take the view that because ENV1 and ENV2 are not complied with in the way that's been described, that growth 2 is automatically deemed not to be satisfied.
Yeah, no, if it's your case that the inspector shouldn't be too concerned by the conflict of growth 2 because of other factors, I totally understand that, but I'm struggling to understand the logic of your position that it complies with growth 2 when it's common ground that ENV1 and ENV2 are breached.
I mean, I think it's because I am trying to look at the local plan as a whole, and I'm simply saying to you that there will be policies that will pull you in slightly different directions. That's really what I'm saying. I mean, I don't think.
Sorry, Mr. Brown. I think I understand your point that that's about whether there's conflict with the development plan taken as a whole, and that's obviously something I'll have to consider. I think the question is in relation: is there, in your view, conflict with policy growth 2 or not? I think that's the question that Mr. Smythe's getting at, unless I've misinterpreted Mr. Smythe.
Yeah.
I mean, you know, my proof of evidence and the evidence I've given to the inquiry is that there is no conflict. I can see where Mr. Smythe is coming from, and I think if one wants to take, you know, the literal interpretation of that it automatically means you must comply with every other policy. I just don't think that's a realistic position. But yes, if that's the way you want to construct the argument, then that would be a conflict. But that, you know, that's not my position.
In your view, does the appeal comply or offend with ENV 12, the listed buildings policy?
I think in relation to ENV 12, what I would say is that it as written, it does not, but importantly, ENV 12 is not consistent with the framework. And similarly, ENV 11 is not consistent with the framework because they don't include that balancing exercise that the framework tells us we have to carry out. So to that extent, ENV 11 and 12, I would put to you, are actually out of date policies. And therefore, I don't think they need to detain the inspector unduly. I think the inspector needs to rely on the advice in the framework.
So when the inspector is reaching a view as to whether there's compliance with development plan as a whole, he can note the following: the appeal offends ENV 1, ENV 2, ENV 11, ENV 12, and upon a literal reading of growth 2, it also offends that policy.
I mean, subject to the caveats I've given, yes, that would be a reasonable position for him to take.
And on that basis, is it still your view that the appeal complies with the development plan as a whole?
It is still my view, because I would still maintain that you have to look also at ENV 10, the Greenbelt policy. And I think we comply with the Greenbelt policy because I think we have managed to demonstrate the very special circumstances. And I think if you do that sort of balancing exercise and you look at all the policies in the context of what I've already said, that some will pull you in one direction and one will pull you in another, my judgment would be that taken as a whole, the proposal complies with the development plan.
Can we take up HOU 6? Is it called up in 1.3.1? 3.1. Yeah, sorry, it's called up in 3.1.
I'm just going there, just bear with me. Yeah, I'm there now. Yeah.
Yeah. And I just want to explore the extent to which it can be said that the appeal complies with this policy. Just taking the council's approach, if you look at the top of page 51,
yep,
it says, as an exception, proposals for care or nursing homes may be acceptable on sites outside development envelopes where, and then gives 3 bullet points. I know your case is that this doesn't refer to the appeal site because it's extra care. I'll come to that in a moment, I promise you. But if the inspector applies this criteria, we can agree, can't we, that the appeal would offend HOU 6.
Sorry, could you just repeat that? Sorry, just.
Yeah, I'll come to your point that this bit of HOU 6 doesn't apply because it's care and nursing homes, not extra care. I'll come to that point later, I promise. But if the inspector takes the council's approach and applies this part of the policy to the appeal, we can agree that the appeal would not comply with this policy by reference to the second bullet point.
Yes, but what I would also highlight is that particular bullet point is inconsistent with growth 2, because growth 2 very plainly refers to a proposal not having a significant adverse effect, whereas this one here is a rather more strongly worded policy that says it should simply not cause harm. And I can't really conceive of too many circumstances where a development outside a development envelope will not potentially cause an element of harm, however it's perceived by individuals. So I think there is actually a bit of an internal conflict of the plan here.
Well, when it says the proposal will not cause harm, the inspector should read into that material harm, shouldn't he? You're not suggesting the inspector should have regard, or if there's immaterial harm, that would give rise to breaching policy HOU 6.
Well, I think the issue there is that something which causes a low level of harm or a moderate level of harm, and it is common ground here that there would be those levels of harm in relation to landscape character and also to heritage considerations. if you read that policy absolutely explicitly, it would preclude development. But as I say, if you look at growth too, the position is expressed rather differently, and I think is a more rational, more reasonable way of viewing needed development that has to be provided outside development frameworks.
If I could deal with the point you dealt with in chief, that the inspector ought not to apply this element of the policy because it refers expressly to care or nursing homes. I don't think that's a point you raise in your proof, is it?
I think it is actually.
But I could be wrong.
I think so. If you look at 3.44,
Yeah.
I do say the first part of the policy appears to me to be applicable because it references residential care accommodation. This appears to be a rather broader definition than used in the second part of the policy, which applies to care or nursing homes only.
Yeah, actually, in fairness, 3.45.
Correct. Yeah, that's correct.
Yeah, no, that's fair. That's fair. So if you're right, and the second part of the policy doesn't apply to extra care and only applies to care or nursing homes, it would follow that there'd be a higher, more stringent policy test for care and nursing homes than for other categories of residential care for the elderly.
Well, that is what the local plan says. I did not write the local plan, but when you look at it and you look at the language that is used, that is exactly what it says.
Is there not a logical inconsistency in your evidence? And I say that for this reason, that when you gave evidence earlier, you agreed that when growth 2 refers to residential care homes, that was a shorthand, which includes extra care.
I did, yes, that's correct.
And yet, when you come to read HOU 6, you then seem to adopt a sort of literal, legalistic reading of the policy so as to disapply the second element of the policy. It just seems that you're not being consistent in how you're approaching the wording.
Can I just find a reference that I want to take you to, and I'll answer the question.
Yeah, no, please, yeah.
In doing so, I'm actually going to the previous appeal inspector's decision, which hopefully you all have. Sorry, I just need to find the reference. I should have had a note of it.
No, please, yeah, please.
Thank you. I was rather deeper into the document than paragraph 27. Thank you. So yes, about halfway. It's at the top of page 6 of the inspector's decision letter. It's stated quite clearly there. However, the second part of the policy, despite being discussed at the inquiry, explicitly references care homes and is not relevant to the proposal. So in that sense, that's the position I take as well. The previous inspector agreed with that. That's the position I take.
So you've agreed with that sentence. Do you agree with the next 2 sentences?
Going back to the policy. Well, I mean, I think what the first part of the policy says, that residential care accommodation should be located within a settlement. Now, it doesn't explicitly say whether that means within a settlement boundary or whether it can be outside. I mean, that's not clear from a reading of the policy. It simply says that the settlement needs to offer a range of services and facilities. So I confess I'm unclear on the point, because being outside the settlement boundary, if one read the first part of that as saying that this policy would not therefore apply, because effectively you're relying on the exception granted by growth 2, then it would not be relevant. Otherwise, if the view was that something outside the settlement boundary but clearly connected with the settlement, then obviously it would apply. But I think that's going to be a matter for sort of the inspector to sort of judge ultimately. The policy obviously does go on to say there should be no adverse impact on the character of the locality or residential amenity. And that's a reasonably narrowly drawn point, it seems to me. It's not, it doesn't specifically reference heritage, it doesn't specifically reference landscape, it's the character of the locality generally. And our evidence to this appeal, Mr. Crawford's work, etc., demonstrates that, you can assimilate this development into the area without having a significant effect on the character of the locality. So, I'll be frank, I am slightly uncertain on the policy because it's not very clear, I don't think.
The inspector says in the final sentence, "I've found harm to the character and appearance of the area, and therefore the retirement care village element of the proposal conflicts with this policy." Now, this policy is HOU 6.
I see that, and that
Do you
was
agree or
his
disagree with that?
that was his judgment. Well, as I said, I've just said I think it's not entirely clear. But I think in any event, I could certainly say that I don't think there is conflict with that, because either it doesn't apply because we're outside the boundary, or it does apply. And I don't think that we have, taking a longer term view of this proposal, at 15 years, which is obviously what was addressed in the LVIA, I don't think we have an adverse impact on the character of the locality. And I think it's agreed that there is no residential amenity point. So I don't think there is conflict, but, I think the policy is not very well written.
But drawing these strands together, we can agree that the appeal offends ENV1, ENV2, ENV12, a strict reading of growth 2, and offends HOU 6, again, if one takes a strict reading.
No, I think I've just said I don't think we do offend HOU 6. So I don't accept that.
But if we take up HOU 6, it says the design and scale of scheme should be appropriate to its settings and have no adverse impact on the character of the locality. Given that it's common ground that there's low to moderate harm to the character and appearance of the area, then it follows, doesn't it, that there is a breach of HOU 6.
No, again, I don't think so. I mean, I think what we're saying is that there is a short-term low to moderate harm in landscape setting terms and in heritage terms. But I think if one takes the more pragmatic, more practical view of development once assimilated, I don't see that sort of applies, to be perfectly frank.
You've inserted two words: short-term harm to character and short-term harm to heritage assets. Where do you get that from?
It's just an assessment that I've made. It's not, I accept it's not in the policy.
Is it in your proof or in the statement of common ground?
No, but I'm drawing on some of the other evidence before the inquiry on impact, both heritage impacts and landscape impacts. But no, it's not in my proof.
I mean, just to be clear, it's not the landscape or heritage assessment that is only low to moderate harm before the trees get planted. The conclusion about low to moderate harm is post mitigation, isn't it?
Sorry, say again.
When you use the word short term, that sends alarm bells ringing, because it makes me think that you're suggesting to the inspector the harm is for the next 5 years before the trees grow and then the harm is mitigated. But that's not what the evidence is. The common ground is low to moderate harm.
That's true.
Yeah, okay.
That's true.
Fine.
Sorry, if I may just come back, I would still nevertheless point out that in relation to HOU 6, I think there is a fundamental contradiction with growth 2. And I think I've made that point. I don't need to perhaps make it again, but I would just emphasize that I do see that contradiction.
No, that point's been noted, Mr. Brown. Thank you.
Let's assume that the inspector accepts your case and allows the appeal, for the sake of argument, in 2 months' time. And when would you expect the reserved matters application to be in?
So that's something I have covered in my proof, and I would refer everyone to paragraph 3.109, where I have I've indicated an appeal determination November, December time, so 1 to 2 months. I think, as is known, Axis is a land promoter, so the site would be then obviously sold, and we would expect that to happen around about February of next year. There is interest in the site already. We would then anticipate some pre-application discussions with Mr. Phillips and relevant colleagues, and a submission around about August of next year. Now, obviously, we can't absolutely dictate when that will be determined, but bearing in mind the nature of the proposal, the scale of the proposal, and no doubt the public interest, we have suggested April 25 might be a reasonable date to assume for determination. And then you can see also their suggestions around commencement of development having dealt with planning conditions and first occupation.
Yeah, and the appellant has been promoting this site for Extra Care since 2019, hasn't it?
That is absolutely, that is evidence before the inquiry.
So if one were to apply this strict 5-year parameter time horizon, then your appeal site would fail that, wouldn't it?
If you go right back to the starting point, then it would. But I'd like to make some sort of further points in relation to that. Firstly, and most obviously, this scheme has had to go to appeal twice. And I have indicated in para 3.110 of my proof that that has essentially lost us 2 years out of the overall timeline. And I would also just point out that since pre-application consultation started with local residents and others, we have had a global pandemic, and that has obviously slowed things down. That's the reality of the situation. I think what this probably really emphasizes and gives added weight to is our contention that for any other site which is not yet in the planning process, whether not even any pre-application discussions on, or not even having been secured, the possibility of actually achieving development within a 5-year period on this evidence is not going to be realized. So what we have here is a scheme that can deliver to meet the critical need, we say, by November 2026, and nothing else can. So I'm not entirely sure where your point goes.
Well, could not an alternative inference or conclusion which the inspector could draw is the fact that the appeal site is going to take 7 years, that the inspector, when approaching the issue of achievability of alternative sites, should approach the matter with a degree of flexibility and common sense?
That is not the agreed position before this inquiry. It is in the statement of common ground that a 5-year period for achievability is the period that should be worked to. As you will know, in relation to the first appeal, the period was set at 3 years, and the previous inspector thought that 3 years was too short a period of time, and thought that that was one of the faults of the previous alternative sites assessment. Following pre-application discussions with the local authority, and I think also consistent with what the previous appeal inspector said, the timeline was set at 5 years. And I think what the inspector, respectfully, sir, needs to do here is to recognise, the urgent and critical need. And I don't think one should apply any greater flexibility, because to do so will be to mean that people who need this accommodation now will have to wait even longer. And that is a completely unacceptable position.
Can I, if I could just, I'm sure this line of questions is coming to an end imminently, not least because of the common ground position, but just to flag, sir, that had this been an issue between the parties flagged at any time that the 5 years wasn't appropriate, no doubt that would have been raised in evidence by the council, and I would have a chance of challenging Mr. Phillips on that. But of course it wasn't, and so I didn't, and so really it shouldn't, especially given this common ground, be raised up. But I'm sure Mr.
No, I mean, I'm
is moving on.
the line of questioning is, I mean, it isn't approved, so hence why I'm happy for Mr. Smythe to question Mr. Brown on this, but your point's been noted. That
Well,
it's,
noting is one thing, sir. It's not part of the council's case
no,
at
I
any point
understood.
that this is what's been said is wrong, or that a different time period should be taken, particularly when it's in common ground. So had Mr. Phillips suggested that, then obviously I would have been able to cross-examine him. I'm now disadvantaged if the only evidence being given is if it's being raised for the very first time now, and that's not appropriate, obviously. I'm sure this line's coming to an end now. If it is, that's fine. But clearly it isn't right to be taking points in cross-examination that have been flagged, not only by the council's witness, but at any part of their case thus far. Just isn't right.
Okay, thank you.
I'm moving on.
No, okay, if you're moving on, and you do have, if you want to address this point further in re-examination. Okay, thank you. Mr. Smythe.
Yeah, final topic, weight to the benefits.
Yep.
You give significant weight to the particular benefit of providing elderly residential accommodation, don't you?
No, I provide substantial weight.
Right.
You just said significant.
Okay.
If you look at the table in the statement of common ground, which is probably the best reference point for that. We're consistent with the previous appeal inspector on that.
Right.
It's also in my proof of evidence at para 611, page 52.
Yeah. Can we take up document I5, which is the Oxfordshire decision?
I can. You'll just have to give me
Please,
two moments to
Yes,
locate that.
4.36.
Thank you. I'll let you know when I'm there. Yeah, I have the document.
This is 9 days up, 9 days old, isn't it?
It is dated the 10th of October, so yes, it is.
Yeah, and it's the latest decision of the Secretary of State giving his most up-to-date view on the matters which it addresses.
I think that's it is a decision by the Secretary of State pursuant to an inspector recommendation on a specific scheme in Oxfordshire. I wouldn't elevate it to anything above that.
But it's the last opportunity the Secretary of State has had to publicly express what weight he gives to particular benefits on that particular scheme.
As far as I'm aware, that's correct.
And we can, if we look at paragraph 28, sort of internal page 5, the Secretary of State agrees with this inspector and gives significant weight to the benefit of extra care older persons housing. Do you see that?
I do.
and you say that substantial weight should be given to the benefit. So you give more weight than the Secretary of State does.
Well, I wasn't commenting on this particular appeal in South Oxfordshire. In relation to the appeal before this inquiry, that is my position, and I'm echoing the position of the previous appeal inspector.
Right, but by giving substantial weight to the benefit of extra care housing, you're giving more weight than the Secretary of State did in the Oxfordshire case.
I don't know the Oxfordshire case, and in detail. I'm obviously aware of it, but yes, that is correct.
And if we turn to the inspector's report, paragraph 77. Yeah, so it's internal page 36. It's the inspector's report after the Secretary of State's decision.
36. Yes, I'm there.
And the inspector records at the bottom of paragraph 77 that drawing the various strands together of the evidence, that this translates to a need of 964 owned extra care units at the present time, and this rises to 1,465 units by 2041. Do you see that?
I do. I just want to check something first. I just want to see whether this is the inspector's conclusions on the case made by both sides, or whether this is the appellant's argument. I think it's the appellant's argument. But carry on. I do see that.
Well, I mean, the straightforward point is that the need recorded there is nearly 3 times as high as it is in this district. And so the question I'm putting to you is, how logical is it for the Secretary of State to give significant weight to that particular benefit, and you, in a case where it's 3 times smaller, or a third, just over a third, giving it greater weight?
Well, the first thing, just to, by way of clarification, paragraph 78. I'm not making a major point here, but paragraph 78 does go on to concede that the shortfall is not actually 964, it's actually 663 once you have regard to existing supply and developments in the pipeline, which plainly there are in South Oxfordshire, whereas obviously there are none in East Cambridgeshire. I mean, as I say, I was not involved in this case. I can't really go into any detail to help the inspector in relation to how the inspector in that case, or the Secretary of State, came to this particular conclusion. I am aware that the appellant's assessment of needs was criticised by the local authority. And I think there is a reference later on, I think it's at paragraph 169. So from 164 onwards, the inspector's obviously dealing with extra care housing. And there's a lot of comment here about prevalence rates. Now, I don't really want to get into prevalence rates because it's not my field at all. But I do notice that at paragraph 169, and I think, when we're talking about the appellant's new research here, that is what gave rise to those levels of need that Mr. Smythe's just referred to. And it does say that method of research is entirely different and has not been tested at appeal or accepted by any decision maker or form part of any publication for peer review. And other recent appeal decisions are based on a much lower rate of need. So all I would just say is you need to be cautious in how you approach that, because that methodology has been criticised. And all I will say is that irrespective of what was agreed there, I would still maintain that the weight to be applied in this case is substantial. There's been no change of circumstances in East Cambridgeshire, which would point us in a different direction. And I don't think relying on an appeal in Oxfordshire is really very helpful.
So you're relying on the previous inspector's planning judgment that substantial weight is given to that.
I'm not relying on it. I'm just agreeing with it. I mean, it's my position, and I believe it was the position in the first appeal taken by the appellants. So I'm not relying on it. I'm just simply saying that it is their fact.
But you disagree with the previous inspector when he found that there was breach of HOU 6, because you say there isn't a breach.
I'm approaching this, from my own perspective. I'm as the professional witness, I come to my own conclusions. The previous inspector did. This inspector will do the same.
Thank you, Mr. Brown, for your patience. So that's all the questions I have.
Okay, thank you, Mr. Smythe. I've got a few questions actually, and I will ask them now because it's probably the most opportune moment for me to raise them. Just going back to the first point, I think in cross-examination, and I just, again, similar question to the question I asked Mr. Phillips yesterday, but I'm probably going to phrase it slightly differently. In terms of, and Mr. Smythe pointed out paragraph 47 of the framework, which is effectively the statutory duty which is contained in the Compulsory Purchase Act 2004. So that requires development to be in accordance, planning permission to be determined in accordance with the development plan unless material considerations indicate otherwise. And so looking at the final paragraph of your proof, which is 7.6, I just want to be absolutely certain as to how you've arrived at your conclusions and how you say I should determine this appeal. You say in the last paragraph, my clear view is that there are very special circumstances to justify the grant of planning of permission for the appeal scheme, and that the scheme therefore, and I highlight the word therefore, accords with the development plan. Well, I'll ask you, do you have any comments to make on that on the basis of the cross-examination and discussions throughout the inquiry? Is that the correct process for me determining the appeal in your view?
So yes, I think it is. I have said, I think through my evidence and through cross-examination today, that I think when one views the development plan as a whole, and accepting that it is rare to be able to tick off every single policy and say we comply. Obviously, Mr. Smythe did not take me to a number of policies which my proof clearly shows we do comply with. I think viewed in the round, I think that we do comply with the development plan. And that is because part of the development plan is, the application of National Greenbelt Policy through policy ENV 10. And so I do think when one looks at it absolutely in the round, that is the valid approach to take.
So you say it follows that if I find compliance with a development plan, that I would therefore find very special circumstances effectively, because inherent in that judgment that I make would be policy ENV 10, which effectively requires me to do an assessment in Greenbelt terms.
Well, I'm saying your assessment of policy ENV 10 is part of your overall assessment of compliance with the development plan. So, you can't, I don't think you can separate ENV 10 out and that Greenbelt test from the rest of the development plan. I appreciate there is a second stage of very special circumstances to then look at after you've arrived at a judgment on the development plan as a whole. So I suspect we're probably saying the same thing, but maybe just
we probably are. But let me just try one more angle at this question. Do you say then I could find conflict with the development plan, and do you then say that I could still approve the scheme or not?
Absolutely, yes, sir. That is what I'm saying. If you find conflict, the very special circumstances would still warrant permission being granted.
Okay, thank you. Just bear with me. I think there might be one or two more points I'd just like to make. Yes, in terms of, again, looking at the proofs and the statement of common ground as well, if necessary, but if we concentrate on your proof, you talked briefly about in chief and through cross-examination about the provision of affordable housing, which I think you give substantial weight to the provision of affordable housing. And I've heard throughout the inquiry, the importance, the relative importance of the existing situation and future projections in terms of need, in terms of affordable units. My question really is, do you think I should also take into account the number of units proposed in this case? So the number of units is also part of the equation when I determine whether or not substantial weight should be given to the provision of affordable housing. Do you agree with that or not? So let me make it clear, the number of units proposed in this appeal.
Yeah, I mean, obviously, we don't have an absolute number of units at the present time, as you'll be aware, sir, because it's a percentage of the total number of extra care retirement dwellings that we provide. We have indicated that we could conceivably, with the floor area cap proposed, we could conceivably have up to 170 extra care dwellings.
Yeah, so I'm just going to say it's agreed, isn't it? It's 170 dwellings, so therefore a proportion of that would be up to 170 units. A proportion of that would be, and can you remind me of
50? It would be 30%.
Yes,
so it would equate to 51 if it was 100.
So the maximum number would be 51 affordable units. Yes, okay. So taking that figure, if you'd like to continue.
No. So I was just trying to put it into some sort of context. Apologies if that was unnecessary, but I mean, I think it's a meaningful contribution, I think would be my point. I think such are the needs that I think I would still be saying one should give substantial weight, even if it was a lesser number of units, but at potentially as many as 51, it may be slightly less than that. That is actually quite a significant number, and therefore I would say substantial weight is absolutely the right level.
Okay, thank you. I have no further questions. Would you like, is a re-examination?
Yeah, just a couple
yes,
of minutes.
okay, that's fine.
Couple of minutes, please. So just on that last point, in terms of the number of affordable units, 51, you made the point that substantial weight, even if a lesser number. Just again, looking at it in the real world, is it any comfort to the one person who needs that affordable housing that someone else who was previously needed has been given a unit? Is their need diminished by that in any way?
No.
And then secondly, please, the point about the 5-year time horizon, which came, as I say, slightly out of the blue earlier on, that the needed perhaps look beyond that, despite what's said in the statement of common ground. Your point, please, about whether it's the point was put to you, well, look, this site took a number of years to get from first interaction with the parish council to where we are now and delivering units. So shouldn't we be looking for other sites that could come forward in that longer timescale? You said in response just to quote, you said, this emphasizes, in fact, the contention that for any other site that's not in the planning process, the possibility of achieving development within 5 years won't be realized. Our scheme can deliver the need and nothing else can. Just in relation to that point, please, when do we form this view as to whether sites can come forward? Do we do it by reference to when our site started many years ago or now?
Well, I think the baseline has to be now. The need, which is not at issue before this inquiry, is now. We know that is a need that is going to grow, and Ms. Venables took us through that yesterday. And therefore, the starting point should really be where we are here today, not some notional date 3 or 4 years ago.
And so when the council says, well, hang on, look, sites can take ages to come on. Look at yours. It's taken ages to get this far. Does that help the council's case or undermine the council's case as to how long other sites not yet in the system or just coming to the front end of the system are going to take to get a spade in the ground and units occupied?
I think it significantly diminishes the council's case.
And just panning out again, just the bigger picture, accepted, of course, in common ground in cross-examination yesterday. On the evidence, have you seen any sign of any site other than ours coming forward to meet this need?
I don't think we've heard any evidence of this inquiry which would suggest that.
And then lastly, please, in relation to policy compliance, paragraph 55 of the inspector's decision.
Sorry, just.
Yeah,
55.
Para 55, please, yeah.
Yeah.
And there we had the point, it is in the context of housing 6 and growth 2.
Yep.
But the inspector halfway down says it's impossible to imagine a scheme of reasonable scale proposed on a greenfield site that wouldn't cause some harm. That's recognised by the framework, which has the more balanced approach. 7174B only seeks to recognise the intrinsic character and beauty and doesn't prevent all development in the countryside. Para 79 states villages should be allowed to grow and thrive. So, and the inspector's conclusion was that I therefore place limited weight on this conflict, the conflict they've identified in Para 55, and the associated conflicts with 1, 2, and 6 of the plan. On that basis, on the lack of flexibility in those policies, do you share the inspector's view that limited weight should be given to any conflict, or do you reach a different view?
No, I would agree with that. I think it's the pragmatic position to adopt in the circumstances.
Thank you very much indeed. So those are questions in examination.
Okay, thank you. Mr. Brown, you'll be relieved to hear I have no further questions, so you can take your seat again. We will have an adjournment now. So we will come back at 22. We are going to move on then to the conditions and planning obligations session. Is the room available? I do intend to finish by 1 o'clock, but does it need to be vacated by a certain time? By 2 o'clock. Okay, well, we'll still hopefully finish by 1 o'clock. So yeah, we'll adjourn now and come back at 20 to 12. Thank you. Like my machine decided to restart, so I've had to wait for that.
Spared our blushes, sir, because we were trapped in the, between the doors, so we.
All right, okay.
About 30 seconds ago.
Okay, so we'll reconvene now. We're moving on to the final roundtable session, which is conditions and planning obligations. Is there a preference as to which order we deal with these items in, or not? Yes, okay, that's fine. So we'll deal with the conditions first. It will be helpful to have open the statement of common ground, which contains the list, or the latest list I have in terms of agreed conditions, and the email that I sent earlier with some suggestions. I think it's easier just to go through them one by one. I mean, I'll skip over conditions where we don't need to have any discussion. From the outset, are parties satisfied if in writing my decision, if I was minded to allow the appeal, if I make small alterations to the wording of conditions as I see fit? Yes, okay.
Yes, sir.
Okay, thank you. Also, and is there a version of a new condition, or is that going to just be presented as part of the session? I don't mind either way. Do I need a copy now, I suppose, is what I was asking, or do you want to just wait until we get to that point and we can discuss it?
As I understand, what we had a draft that we've been discussing even up until the last few moments, and I think some changes are going to be proposed to it. So perhaps we could talk you through where we've got to, and then either first thing in the morning, present you with a clean version of the agreed condition, picking up the points of discussion. I think it probably would help for the inspector to at least have the original note, so that then we can talk you how far we'd got, and then orally.
Yes, okay.
Yeah. So if there's a hard copy of that floating around anywhere, could we get that to the inspector? Here it is, sir. Sorry, it's in front of me. Here it is. I wouldn't at the moment necessarily give that an inquiry notice, because
No, okay, that's fine.
we'll talk you to where we've got to and update it.
No, it's just really a supplementary note for the purposes of the roundtable session, which is subject to additional changes. So that's fine. So we'll work through the conditions numerically then. And as I say, I'm using the statement of common ground conditions. I'm sorry, I just need to find my email as well. So the main, and it might have been picked up in this note actually, but I did note that the condition number 1 didn't seem to refer to the matters that were subject of the appeal, i.e. there was no reference to appearance. Oh, sorry, there is. I've missed that. It was late last night, so please accept my apologies. But yes, it was the commas just thrown me, so it is in there, so we can ignore that. Is it worth introducing? Is this in relation to condition 1, the note, or?
It would be, yes.
Is it worth just introducing that now and dealing with it?
Yes, it is. Good morning, sir. You've not heard from me yet.
No,
today,
good morning.
but,
Could you remind me who you are again, please?
Of course, my name's Matt Hare, and that's H-A-R-E, as in rabbit. And I am planning director for Axis Land Partnerships.
Yes, and you were introduced on the first day, I think,
I
as
was.
well. So thank you.
That's correct. Thank you. The note that you've just been passed, notwithstanding what we mentioned a moment ago about we're still talking about that up to a second ago with the council, that does pertain to the existing condition 1 in the list of possible conditions that in the main statement of common ground, and what the note does is it picks up on the point that's been raised about the additional access points that are relevant to the application, but for which there's not at present a detailed plan showing the design and location of those access points. And what we are suggesting is that, as it stands, condition 1 be amended so that within the definition of the reserve matters, there is a category that deals with additional accesses, and those additional accesses are broadly defined within the condition. And you can see in the 2 scenarios that are set out in the note that depending upon whether you accept the amended plans, we either have a scenario where the additional access is simply defined or solely defined as comprising of a pedestrian link to the public right of way known as 25/10. And that is the public right of way that runs on a north-south bearing adjacent to but outside of the western edge of the application area. Or in the event that the amended plans are not accepted, those additional accesses are defined as both that link that I've just talked about, and also a pedestrian link to Rowan Close. And that is the way in which this almost exactly this matter was addressed in condition 1 of the Stapleford appeal decision, which you will see is core document 4.6. So it is before the inquiry, and you'll see the inspector there. My recollection is that was his wording for that condition. Now, what we've latterly just been discussing with Mr. Phillips is that there may be a preference for that actually to be extrapolated from condition 1 and set out into its own condition, which we think could be absolutely fine. And we just need to write that out in longhand and share that with Mr. Phillips and reach agreement on it.
So that it's not a reserve matter, it's actually a detail.
Okay, thank you. So the way that the conditions worded, or the 2 conditions are worded at the moment, you're asking me to make a decision on one or the other. So in the event that the amended plans are accepted or are not accepted. Now, my thought process on this is the plans are put forward on the basis that matters that are in your control might or might not come to fruition. So I understood the situation to be that you would implement the access if you possibly could, but you might not be able to, and that those are matters that are outside my gift, and the things that are up to you to kind of address. So in that sense, are you really asking me to make a decision on 2 plans, to choose between 2 plans in having regard to what I've just said? Is that really the situation?
Yes. So what we are asking you to do is to determine our preference is for you to accept the revised plans and determine the appeal on the basis of them. And the reason,
Yes, okay.
The reason for that is because although we're not sure as to the extent of the issue, an issue has arisen, and we can't hand on heart tell you now that it will be resolved, in the next week or so. So that's where we want you to go. But obviously, if you have an issue with that for any reason, that you don't, it's your decision in due course, and you say, I'm not going to determine the appeals on the basis of those revised plans for whatever reason, then you come back to the original plans, obviously, and determine the appeal on that basis. And what these conditions are designed to do is to give you some wording, which you would then use depending on where you go.
And Mr. Phillips or Mr. Smythe, any comments to
I
make
think
on that?
Mr. Hare has explained it quite well. My beginning concern was if you put it into condition 1, you're granting a consent of outline that includes access, and then your first condition, you're straight away removing it as a future reserve matters. So I thought it'd be cleaner if it was its own separate condition. So it would come along with the first reserve matters, whichever one it was, and then potentially implemented prior to like the first occupation of a C3 dwelling.
Yes, well, that would be my preference, but I don't know. I will ask, does that bring about any legal issues, or are you satisfied that you can in fact provide details of one access and the point of access in relation to another access, in this case, a pedestrian access, and that satisfies the requirements of the order?
Yes, so in short, and also I'll address you that in closings. You'll see actually at the foot of that page, I think there's a reference, isn't there, to the, yes, under the references, it tells you the relevant section of that order, which says where access is a reserved matter, the application must state where, and obviously in our primary position, which is you go on the basis of the revised plans, we would have an application which says the main access is obviously the road, and that's shown. What's come up through the course of the inquiry is the suggestion that, and the acceptance on our part, that there will be scope to create additional accesses, and there's absolutely no reason why in that situation a condition can't be imposed on the grant of planning permission saying, look, you've applied for reserved matters, that's all fine. Actually, we need to do something else. We can secure that by condition. And although in Stapleford it was done in the context of badging that as a reserved matter, you get to the same position, which is you can't do anything on site until you've got that sorted.
Yes, okay. I mean, I don't want to make a big thing of this because I don't think it's particularly contentious, but at the same time, I don't want to fall foul of a procedural matter, which could, a condition might be incorrectly implemented, which is not in accordance with legislation. So I just need to be a bit careful on that. My preference will be that the condition is separated just to make it cleaner.
We'll do that, sir.
My second question, which follows from that, is the public right of way. I did see some comments, and it was a few days ago now, from the county council, I assume, in relation to the footpath. And it's just kind of sprung to my mind in relation to legislation. So would there need to be some kind of, not a footpath diversion as such, but legislation under the Highways Act in order to connect to a public footpath? Is that something that's been considered? Have you, I mean, I assume you've not consulted the county council. Any thoughts on that point? And how does that affect my decision? Is that material to my decision? How does it affect the condition? Any thoughts on that?
The county council haven't been consulted on the proposed amendments, and obviously they would need, any developer would have to get consent to join onto the public right of way. So that consent will need to be granted.
Yes, and that's my point. So it could, it doesn't seem to me that that's a guaranteed position. It will depend on a different regulatory process. Hence, well, I'll leave it. It's up to you really to try and put to me whether you think the condition meets the tests.
If I could, I think a separate consent would only be required if we were to be doing works within the public highway. So in the same way that you have the section 278 process for works within what we traditionally think of, I suppose, as the public highway, so the roads and footpaths there. If we weren't doing any works within the actual defined surface of the public right of way, then I don't think any extraneous consent would be required.
Okay, well, if that's your position, I'm not entirely convinced by that, if I'm being perfectly honest, just having previous experience dealing with issues in this field where inevitably there would have to be some, I imagine there must be a connection of some description to the existing public footpath. There would have to be some kind of physical connection to it. I don't know the answer. I'm just putting that out there, that I suspect it might need some form of other consent. is it best for me to leave this with you and then come back in the morning on this point?
So absolutely, let's come up with a clean condition, and then both parties can knock their heads together as to whether there's an issue. My starting point is that it's the fact that a condition might require something else to happen, and there's no that's no statutory bar in its own right, but we can cover that all off in the morning and in closing submissions if need be.
Yes, okay. So Ms. Phillips, you're happy with that?
With that approach, yes. For us to discuss it, we'll come back to you tomorrow morning.
Yes, yes, okay. So we can move on from this condition for this session, okay. So I'll keep the note, but it's probably subject to change, I imagine, potentially. It might as well just, yeah, take it away. So it's not before the inquiry. Thank you.
Sir, just before we move on from condition one, there's one other point I just wanted to make with respect to that condition, and this has been discussed with Mr. Phillips a moment ago as well, and that is if you look at many of the other conditions, draft conditions, they're worded so that they make a distinction between the two discrete elements of the scheme, i.e. the affordable housing element and the C2 element. And they say you can't carry out any development within either of those built development areas as shown on plan XYZ, and the plan is specified until you've agreed something for that specific built development area. Mr. Phillips and I were just saying a moment ago that we reflecting on draft condition one, we think that would benefit from being worded in the same way, so that would effectively say no development within either of the built development areas shown on plan reference XYZ shall commence until details of the appearance, landscaping, layout and scale for that built area have been submitted to and approved in writing by the local planning authority. And we can give you an agreed form of wording for that.
Yes, it's probably, I mean, I could take that away and consider that, and in the event I allow the appeal, I could take that on board. It would be more helpful to me if you could formulate a condition for me to consider. There's no reason in principle why that shouldn't be imposed as a condition in the event the appeal is allowed, providing the council is satisfied with that approach.
Yes, I'm satisfied with that approach.
I mean, sometimes there are phasing conditions and then you work from that through the suite of conditions. There isn't a phasing condition as such here, but I know that, you know, the conditions are worded as though they kind of are phasing the development, and the two constituent elements, aren't they, is effectively the reason why it needs to be split up. Yeah, okay. That's fine. Okay, so we'll come back to me on that point as well, with another revised draft condition for me to consider. Condition 2, the only points I had to make on here were about the additional plans that might need inserting. Are you happy for me to do that? And if I do that, does the existing list need amending in some way? So it's just inserting those as opposed to, I don't need to take anything out because it's well, actually, do I need to take something out? Because, but I don't think they replace them. Because no, it's fine. You've put to me that both plans are for my determination, so I wouldn't be approving both. At the same time, I would be choosing one of the plans,
Exactly.
surely.
And so the two revised plans, if you're with us, you would insert them into this list and you grant permission for the scheme as revised.
As revised, okay, and I'd substitute that for the existing one.
Precisely.
Yes, that's fine. Okay, that's understood.
Yeah.
I am going to skip through conditions. So if anybody does wish to make any comments on some of the other conditions, please shout out. But I'm going to move on to condition 5. And I have to remind myself what I've said about this condition, actually. It's similar to what we've just discussed really about the first condition. Are you satisfied? Are you happy with a condition that requires a single construction and environmental management plan?
I think your question is right. So I think it should say it should allow for separate construction environment management plans for each area. And it as written, it doesn't quite do that.
No, okay. And the other point I noted is again, I think it's present in some of the other conditions. It's an old-fashioned tailpiece condition, which isn't really something that's used anymore. So, Mr. Phillips.
I'm happy the tailpiece removed unless otherwise agreed. Just on the single or the two Kemp issue, my concern would be obviously they share the same access that would have to be built. And obviously that access would have to be included in the Kemp. So whichever one got built, they're both going to have to come off the same construction access and road. So I don't think this one is so easy to separate the two.
Yes. Any comments on that? That's not. I've not thought about that actually.
Actually, as you say that, Andrew, Mr. Phillips, I think that's why we worded it. We didn't make the distinction in that. It was for precisely that point.
That was my understanding. Yeah.
Yeah.
Yes. Okay.
Yeah.
Well, I'm not overly precious on either approach really. If you're happy for it to be as is, I'll obviously review it on that basis.
I think, sorry, sir. I think there's some case to say it would potentially be less complicated for those parties that will be carrying out the construction of the, potentially the separate elements, to have separate construction environmental management plans to be submitted for each. But if you felt very strongly, or if the council felt very strongly that it must be a single Kemp, then I think that could be acceptable as well.
Well, just in the point Mr. Phillips just raised, so it refers to plan number 003. What does that actually show in terms of the areas? Does it set out the two areas, and does it include the access?
It defines the two areas, and it does show an indicative access road location.
If I could come in, sir, it might be helpful if Mr. Hare agrees. It could be subdivided, but as long as it includes the access arrangements as well.
Yeah, I think could the condition be subdivided, but just there's a requirement to provide construction details of the access or something, just to make it clear that it's including the access, and whoever's first might have to discharge that requirement, or both might have to discharge a requirement, but as long as it's clear that construction details of the access need to be addressed as well.
Agreed. Thank you, sir.
So you're happy to leave that with me rather than you rewrite the suggested condition? Okay. Yeah, number 6, really just asking the council, assuming it's come from the council, just to explain really the what the condition's trying to do, which I think I understand, but the mention of a 30-year period, is there a reason? Where's that figure come from? Is that something that's in policy or?
Biodiversity improvements, we usually try and get in perpetuity. However, obviously perpetuity is a very long time, and 30 years is the standard, I believe, being put forward in the biodiversity net gain sort of element. So that seems to be the new standard.
Yeah, I mean, I've no immediate objection to it. Just justifying the reason. That's all. Any view from the appellant?
No, we've agreed to it, sir. So as long as you're happy.
Yes. Okay. Well, we can move on from that condition. Condition number, and I realise there is a new condition in there as well that's not numbered, but I've no comments to make on that. But just realise I might have to obviously amend the numbering of the conditions. Number 9. Yeah, so again, ask a question to the council. What's the policy basis for the condition, but particularly the reduction in 10% reduction in carbon emissions?
The policy is ENV4 of the local plan, if I can borrow that. And we've recently adopted an SPD, which is 10% above, and I omit older building regs. So the dwellings will probably be covered now by building regulations, the C3 elements, but I don't think the C2 element will be covered by any specific improvements. And obviously to ensure that the development meets the criteria of sustainable developments, it should come forward some energy efficiency or improvement methods.
Yeah, so I'm looking at policy ENV4. It doesn't state 10%. It does refer to the Code for Sustainable Homes, without reading through the precise details, and BREEAM as well. So it's more a question of the 10%. Where does that come from?
That was our standard as we worked to. The SPD required 20% above older building regs. So it becomes quite complicated because obviously there's parts of this that are covered by building regs and parts that are not. So I've gone with suggested a starting point of 10%.
So the SPD, do I have a copy of the SPD?
I can provide a copy if you need it.
What's the title of the SPD? Because I did download some, even though it's not before the inquiry, just in case there was any questions in this session. So I might well have a copy of it.
I think it's a climate change SPD, but I just want to make sure I got the title totally
yes,
right.
well, I do have that that document. It may well have been provided as a core document. I'm not sure, but I do have a copy anyway.
But I think the complication for you, sir, will be that of the C2 element is quite a mix of things. It's flats or houses, because we don't know the design of it. But obviously there's going to be elements of like gyms, nail bars, as mentioned previously, which are going to have different parts of the how you do your sustainability calculations. And whether it's BREEAM, which is like for businesses, how much is covered by BREEAM. So I've tried to come up with a condition with the other side that sort of balances all that out.
Well, I'm wondering whether a scheme should be submitted and agreed, because I just don't know where the 10% comes from and whether it meets the test. Are there any views from the appellant? I know you've no objection to the condition because it's agreed, but having had this discussion, any further thoughts?
We certainly, I think, having listened to the discussion, a scheme would be a good way to proceed, and we'd have no objection to that.
Yeah, that would be fine with me. As long as we had a scheme that brought forward reasonable sustainability benefits for the required elements.
Yes. So wouldn't be prior to commencement? Would there be what would the trigger be?
Prior to commencement, because sometimes you can do underground works to meet this, like ground source heat pumps, and then it'll be implementation prior to occupation.
Any thoughts?
Apologies. So we had agreed no development above ground level. Would be the
Sorry,
trigger.
yes, yeah, because I think we agree you weren't seeking to do ground source heat pumps or that sort of nature. You weren't expecting that.
So no development above ground level and a
Yeah.
scheme, and I can obviously look at this in my own time and decide if the condition meets the tests in its revised form, and if so, the wording of it. But in principle, you're comfortable with that approach?
Yes, yes.
Thank you, sir.
Moving on, condition 10. I'll have to read this condition again, but the note I've made is it's the fire suppressant system, sprinkler system, which I think the fire authority have recommended. Again, I'm not overly precious, and I understand what the condition is intending to achieve, but is it not covered by building regulations?
My understanding for the C2 element, it's not covered by building regulations. However, obviously, I'm happy to go and check with my building control colleagues if you wanted me to. And I think so. You said you understood the need for it, so.
Yeah, I mean, it's just whether it's duplicating other legislation really as to whether
Yeah.
it should be imposed or not.
So I don't think it is, but I can double check for you.
Any views from the appellant?
In terms of the building regulations, I'm not an expert on the building regulations. For the C2 element of the scheme, it's possible that a variety of different forms of fire suppressant could be used, because some of those units may take the form of bungalows, for example, and it would be unlikely to have a sprinkler system in those sorts of units, I would suggest. But I think the way it's worded gives sufficient flexibility in that it says, and in respect of the C2 use, a sprinkler / fire suppressant system shall be submitted to and agreed in writing. So
Okay.
Notwithstanding your comments, I don't think we've got any huge issues with that.
No, that's fine. Well, I don't have any evidence to say that it is duplicating other legislation, so I'll take that on board. But there's no objection from either party on that. Moving on then, condition 11, is this not really, this is a layout matter, as far as I can tell? Or is this leaving the site? Okay,
Yes,
leaving the
this is
site.
site. So obviously you could build out part of the site without sufficient turning space. And then you wouldn't be able to leave and enter in forward gear. So it's just making sure that when you get to the occupation, it's been built out fully enough to allow it. And obviously the end part is to ensure that it always remains. So you can't lose those turning areas.
I'm still not entirely convinced. I think that would be something you'd consider as part of the layout, to see if the layout provides sufficient space in order that vehicles can maneuver to and from the public highway. And I know access has been considered now, but the layout matters are about circulation space. Any thoughts?
I think that's probably right, and you could have obviously a condition at that stage saying make sure that that's in place before occupation. That can be imposed at that stage once you've got those details. As long as that's secured, then the mischief that I think this is directed at, which is people backing out onto the road, would never happen.
Mr. Phillips, I'll give you an opportunity to come back on that.
Yes, obviously, put it here because obviously it's how when you put condition on access or layouts. But yes, it could come forward at the layout stage to ensure that it's permanently maintained, provided before occupation.
Okay, well, I'll take that away and think about that one. Condition 13, again, I think this is a condition that we wouldn't use anymore or not advocated anymore. It's the tailpiece condition. And then moving on, and I am skipping through the conditions here. So as I say, Mr. Phillips or the appellant, even if there's anything you'd like to mention on the other conditions, then please do so. Condition 20. Yes, so can you explain what this condition is trying to achieve?
Of course, as I think Colin Brown suggested yesterday, the roads may not be adopted. So obviously you may have a very long stretch of access to the care facility and the affordable housing. So it's just to make sure it's never causing an issue to the public highway. Or elements of it may not be adopted. So it's making sure there's no barriers that would stop a car entering and leaving safely onto the public highway. So the 10 meters is to allow cars to pull off and so they don't have to reverse back onto the public highway.
Yes, I mean, the condition there as it reads is across the approved vehicular access. Is it not? So is it requiring that there's no obstruction? So you can't put a gating system in? Is that what it's trying to achieve?
Yes, that is correct.
Only within the first 10 meters off the public highway. So
Yes.
if someone's driving along, they turn in, they don't find a gate there.
Yes.
on-
Okay.
on
No,
that
that's
private
fine.
road, which we could otherwise do.
No, understood. Well, there's no disagreement on that condition. Okay, that's fine. And then my other comment was in relation to I know the parameters plans are part of the scheme, and I think just go back to condition number 2. So broadly respect the parameters plans is what condition 2 says, and one of those in relation to heights, land use, development area. Are the council satisfied that gives sufficient certainty over the height of the development? Because the inquiry's been heard on the basis that buildings would be no higher than 10 meters.
I believe that does give enough assurances. My only concern when it was going forward in discussions was to ensure these were broad in accordance, because obviously scale, layouts, and design will have to come forward at the reserved matter stage if you were to grant approval.
Yeah, so if, for example, a building came forward at 12 meters, you would say, well, it's not in accordance with the outline. Yes, okay. Any thoughts from the appellant?
We did have a bit of discussion about this when we were agreeing the conditions. And initially our position as appellant was exactly as you've just discussed. You should be tying down the maximum heights, because that's the evidence that's before the inquiry. We'd have no issue in that being more precisely controlled in the event that you felt it was necessary to do so.
So, Mr. Phillips, if a condition was imposed, I assume there wouldn't be an objection from the council.
Not so that to be precise, yeah.
So forgive me, I hadn't picked up on that point, and I think just from a legal perspective as well, broadly respect is that sufficiently precise for a condition, which then in any event leads on to the point you've made, sir, as to, well, what does that really mean? If the condition just said shall accord with the parameter plans, then of course the council has a discretion. If we come in at whatever it was, 10.1 meters, whether that was accorded with or not. But I think it's unnecessary to include shall broadly respect, because it's not precise enough, I think. So it should just be in accordance with, and then the council can decide at the time whether it is.
My next statement when we was drafting the conditions were we agreeing things that are reserved matters such as scale at the outline stage?
No, I don't think we are.
Because obviously scale is a reserved matters element.
But it has to accord, it has to accord with, sorry, it has to accord with the parameters plan, what comes forward in terms of the built development. And whatever parameters are on the plan need to be respected, because that's what's been, as the inspector says, what's been applied for and would be consented. So I don't think there is that wider point. All I'm looking at is whether it's appropriate to say something should broadly respect rather than accord with, and I think it's better to say accord with. And when that application is then made, the council can say, well, look, you aren't precisely in accordance with, and exercise its discretion, but what does broadly respect mean?
Yes, I take the point, Mr. Phillips. I think the way that the way I read the condition in this room, and obviously I will take this away, it doesn't appear to me that that's approving anything other than the parameters, which would then be subject to further reserve matters. I think the point made in respect of, well, broadly respect, the wording there is perhaps more of a concern.
If you were to change that part of the condition, I wouldn't be overly worried.
Okay, thank you. Are there, is there anything else? Any other? I did look at the consultation responses. I couldn't see anything that was missing from the agreed conditions.
I think anything that's missing on the conditions, I think it's picked up in section 106.
Yes, okay. We'll come on to that. And so the condition session is finished, apart from we'll have a very brief discussion in the morning about the additional conditions that were put to me at the start of the session. Yes, okay. So are we okay to move on then to planning obligate, or the section 106?
Yes, sir.
Okay, thanks. So we'll need, obviously we need the 106, but probably the SIL compliance statement from the council. And yes, I'm probably going to ask you just to talk me through the 106. So I have read it, but I haven't digested it kind of word for word. I've seen obviously the heads of terms and gone through it very briefly. So you'll have to bear with me on some of the questions I may ask in this session, but I don't think it's going to take too long. So my understanding of it is effectively a tri-party agreement. So it's the appellant, the county council and the district council. It will be, it's not, I know it's not been signed, but that's the intention. Yes, okay. So in that sense, there's, apart from the SIL compliance statement, there is agreement between the main parties. I know it's not a signed version, but I assume there's pretty much agreement on.
Pretty much agreements, yeah.
So, can I, just before I forget, there's a tiny point on internal page 6, where, although as you've identified on the front, it refers to Bottisham Farming Limited. There's then the definition of appellant is Axis. We'll need to just make sure that the people who signed it and therefore are caught by it, it's appropriate. But that's only just come to my attention. So we'll work through it and make sure that it all plays through.
Yes, okay. Is there any agreement from the district council's perspective? Is there anything in here which you still think needs some work? You need to discuss further?
From my reading of it, I think everything that I was concerned about has now been included, which was primarily the only leftover point was the sustainable drainage system, which has now been reworded.
Yes, good, because that's one of my questions and you might well have answered that already, so thank you. So as we all know, I'm not going to read out the regulations, but this is in relation to SIL regulation 122, and there are 3 tests. An obligation has to be necessary to make the development acceptable, directly related to the development, and fairly unreasonably related in scale and kind to the development. And I'd like to start off just by asking the council about the SIL regime and the SIL charging schedule. I don't think there's really any evidence before me, but is C2 included in the SIL charging regime, and what about affordable? So could you just talk me through that, please?
So the C2 element is not SIL so we wouldn't seek to collect still money off the C2 element. The affordable housing technically would pay still money, but
It's
obviously
exempt,
it's
yes.
exempt, so they can apply for exemption, which I'm sure they would do.
So that's effectively I think as you say, the correct term is still exempt. But they would have to apply for that.
Yes, they would have to apply before they started developments.
Thank you. So really my main comments on the agreement are, it's fairly brief actually, but I'm particularly interested in and I'll get the terminology correct, but we heard from Dr. Keith, and there's been evidence presented also from the NHS Property Services and Cambridgeshire and Peterborough Care System. They state that a monetary contribution is required due to the potential effects of the development on the Bottisham medical practice. And I heard obviously through the inquiry that in the appellant's view, certainly at that stage, their view, and I think it's also covered in at least two of the proofs, there isn't actually a requirement to make a contribution at all. So with that being said, could I ask the appellant just to set out two things to me? Firstly, why do you say, if indeed you still do say, mitigation is not necessary? And secondly, if I disagree and say that mitigation is necessary, how will the contribution that's in the agreement address the infrastructure pressures that will be put on the medical practice?
In closings on this, just as Mr. Simon said last time around, to persuade the inspector last time around that it wasn't necessary, and so essentially that's our position. Again, it's all about whether there's a proper planning justification for it, where there is obviously NHS, there's funding for GP surgeries come through a different regime. That's our basic point on that. So, and I'll set that all out in closings for you. Insofar as you disagree with that, then this then kicks in and gives the contribution that's been asked for. Beyond that, it's for the council obviously to justify it by reference to policy and like, but that's our sort of binary approach. We don't think it's necessary, but if you're against us, here it is. And it's then for obviously for the council to do what it will.
Okay, so if I put to you then the comments that were made by Dr. Keith, and I appreciate she's not here today, but I did make a note, and she said that an increase in funding won't address the increase in demand. And she did talk about issues with staffing. Now, you don't have to go into too much detail, but I'm particularly interested to understand, do you think I need to take that context into account? And secondly, in your view, would the contribution, if I indeed deem it necessary, would it meet the three tests that I've just mentioned?
Well, that's my point. So we don't think it meets the test, and that's why, as I set out in closings, you should exercise your blue pencil in regard to it, just as your predecessor inspector did. But if you're against us and you agree with the point that there should be some funding, well, here it is, and it's secured in exactly the way that is being asked for.
Okay, and the council's position, statement of common ground, your position is the contribution is required, and in your view, that would address the pressure on infrastructure. And just a second kind of subsidiary point, the policy context. I understand this all stems from at least one of the policies is growth 3. Is that correct?
That's correct, sir.
So, Mr. Phillips, would you like to just come give me your views on the contribution, whether it's necessary, just set out the council's position, please.
Of course, sir. Start with a bit of sort of background context for you. As a case officer, the NHS and ambulance service hardly ever comment on any of my major applications, for large housing schemes. So getting comments from them is a quite a rare thing to get. So obviously it shows they are very concerned on these applications in order to request something they don't normally do. In policy terms, as you mentioned, growth 3 is basically ensuring there's sufficient infrastructure that comes forward to support any developments. And growth 3 does mention health facilities, and so that's quite specific in regards to the locations, but I don't see any conflicts in asking for improvements in this location, given that the proposal is within Bottisham. And it ensures that the infrastructure will meet with demands. The healthcare contribution will increase the GP infrastructure, though obviously it cannot pay for staff wages, which I think is the concerns that Dr. Keith and Bottisham Medical Practice have brought up. It will only provide them the space to have a doctor in, but won't provide the necessary doctors or nurses. And then the ambulance service is to improve the number of ambulances required and the sort of equipment within those ambulances to deal with the extra care village.
Yes, okay, so the definition here is in the agreement in terms of healthcare contribution. This is a formula-based approach. Yeah, so that's slightly different. It's a set figure, isn't it, for the, or is it? Sorry, no, that's I've got confused. So there's two healthcare contributions. There's a C2 and the C3, and they're both based on a formula, depending on how many units are finally realised. And then it goes on to say, in terms of the C2 definition, towards improvements, expansion of facilities. So it is specifically targeted at improvements and expansion of the medical practice. And that is in the intention there is to accommodate increase in staff, patient and resource capacity. So it's a targeted contribution, as I understand it.
Yes, that is correct.
Okay. Okay, I've nothing else on this. I have some evidence, and I appreciate closings are going to address the necessity of the contribution, but I also have the comments made by the health, the doctor, and the verbal comments as well. So I'll take those into account. I was going to move on unless anyone's got anything else on that point. And I think actually the next point might have been addressed because it was a question about sustainable urban drainage, which the council's still compliance statement seemed to raise some concerns with. So things have moved on since then. Is that correct, Mr. Phillips?
That is correct. And it's now, the developer has changed the wording of the open space sites and how it's cascaded to ensure it first comes to a public body. I can take to the page if you give me a minute, but it is page 30 and 31.
Okay, so in your the still compliant, I don't need you to submit it again, but you say it's in the SUD section.
It's in the on-site public open space section. So in short, any sites are in public open space, the council will get first adoption rights, and then it would go down to public bodies.
Yeah, sorry, but in terms of your still compliance, no, that's changed, that's moved on.
Yes,
so
that's correct.
Yes, okay. So where you say it doesn't comply with the Cambridgeshire Flood and Water SPD and EMVA, that's no longer the council's position.
That is no longer the council's position. I now do believe it according to the SPD.
And the policy as well.
Oh, yes, and
Yes.
the policy.
Well, I've no other questions on the agreement, apart from a final version. When's that likely to be before me? I would prefer 2 weeks, but I possibly can accept 21 days. Can we go for 2 weeks, and then if there are problems, request a further extension, and I'll see if I can accommodate that. So that will take us, I will give you an extra day, so will take us to the so we're on the 20th tomorrow, 27th, so that will be the 3rd, Friday the 3rd of November. What would be helpful, I don't need a track changed version, but it would be helpful to submit track changed version to the council, and for the council to comment on the scheme and make sure it's broadly in accordance with the, I don't want a different scheme, different 106, because it would cause all kinds of problems. So maybe make a note of the changes that have been made or something, just so I'm, yeah, if there are any, okay. Is 2 weeks achievable?
I can't see any reason why it wouldn't be, given the small change I think that you're suggesting, so I can't see that being a problem. The only thing to note is I'm not in the council Wednesday, Thursday, Friday next week, but I don't think you need me for the sort of changes you were suggesting. Yeah.
No, and you can't speak on behalf of the county council, I guess, either, so there is that as well. But if we go for the 2 weeks, please, thank you. Oh, sorry, one more thing. Where is the blue pencil clause? Just so I'm clear where it is. Ah, okay, yeah, that's great, thank you.
Sorry, just my document, in the section 106, it ends 4.1.3. I don't have a 4.2.
So you go past the definitions.
Oh,
Internal page number 18.
a second. Oh, yeah, sorry, yeah.
Yeah, we're all reading, hopefully we've all got the same version.
Yeah,
in front
that's
of us.
fine. So I was on a different 4 point
Yeah,
something.
that's okay, thank you. So as far as I'm concerned, that brings this session to a close, unless there's anything else people wish to raise in relation to conditions or obligations. Okay, so we will close this session for the moment, and we will briefly revisit this tomorrow morning. So there's only a couple further matters I want to address today. Costs. We'll do that actually after the site visit. So I'm going to go on site after lunch. It's going to be unaccompanied. If Mr. Ogborn does meet me on site, then I won't be discussing the case with him, and I will politely suggest that I'm just going to be walking the site on my own. If that is a concern for anybody, then they're more than welcome to join me on the site visit. Broadly speaking, I'll be following the itinerary that's been set out by the council and the appellant. And then tomorrow morning, we are set to have closings. I'm assuming that's sufficient time. Yes, okay. 10 o'clock, 9:30. We start at 9:30 tomorrow, and then we will close, hopefully, given enough time for people to get home on a Friday afternoon, which is not usually the best time to travel. So costs. Is there an application for costs by either party? So I'll start with the appellant. No, there isn't. Okay, in the council.
None from us, sir.
Okay. I will ask one more time at the end. I'm not encouraging an application for costs, but I don't want an application to come in after I leave the inquiry. That's the main point. The site visits, I'm not going to discuss anything after the site visit, any merits of the case. So if there's anything in relation to the inquiry, the site visit, anything else people want to tell me, then now is your time. Because after we leave today, it will just be the condition session, and then there'll be closings. So is there anything else people want to make me aware of? No, don't worry, I'm not pressuring people to submit reams of evidence, not on day 3 of the inquiry, but just double checking So yeah, happy to adjourn today, and we'll come back tomorrow. Okay, so the inquiry is 20 to 1. The inquiry is adjourned. I think we'll need to clear the room
Correct.
in its entirety. Yes,
All
so
st-
don't leave
Staff
anything.
Documents, etc.
Can I just inquire about the core document boxes, what you want us to do with those? Because obviously, can they just be, or move to another room or?
I believe we could move into, we've got space in our planning office downstairs.
Okay.
So if you're happy for us to install them in there.
Yep,
Yeah.
very happy.
Is the retiring room available to leave my some not personal belongings but documents? I can leave those in there. Yes, okay. So I'll put some of these documents in my retiring room. If people want to do the same, I'm not averse to that. If that helps people, I'm not going to put anything confidential in there anyway. It's just the documents. But I'll do that. So yeah, the inquiry's adjourned now, and I'll see everybody tomorrow morning.